Good afternoon. My name is Evan Spellfogle. I am Senior Counsel in the New York office of Phillips Neiser and will be your moderator for today's program. First, a few housekeeping notes. If you have audio issues with your webinar, the GoToWebinar connection, use the video for your picture and dial in with the phone for the audio. For CLE credit, you will need to follow two steps. First, listen for the special CLE code that will be announced toward the end of the program. Second, email Susan Wan at the College of Labor and Employment Lawyers requesting a CLE form to complete and return it to her with, among other information, that code number. There are several handouts with this program that should be available to you. They have been downloaded to each participant's screen. Finally, we will take questions as we go along. Please submit your questions on the question box feature of your screen. Now let's turn to the substantive matters at hand. The COVID-19 pandemic has been with us now for 5 months. Rather than coming to a screeching halt, our judicial and quasi-judicial systems have moved ahead, substituting virtual proceedings for face-to-face proceedings. Technology has stepped in and advanced. Private companies have created and improved virtual platforms. Private security concerns have been addressed. And what began as a temporary stopgap measure may indeed be the wave of the future. Under the auspices of the Second Circuit of the College, a special subcommittee of fellows chaired by fellow Darrell Gay has created a series of webinars dealing with the new virtual practice of law. 2 weeks ago, we presented a webinar on virtual depositions. Later this month and next month, we will be presenting a several webinars on virtual arbitration and possibly on virtual trials. Today, we're presenting on virtual mediation. I'm pleased to be joined on our panel by Carla Brown of Charlson, Bredhoff, Cohen & Brown, representing employees, Ariel Sikovich of Safer Shaw, representing employers, Dennis Engel of Colleran, O'Hara & Mills, representing unions, and Martin Wycliffe, a member of Cozen and O'Connor and a full-time arbitrator and mediator. Panelists, let's focus on your experiences in virtual mediation. First, what is virtual mediation and which platforms have you used? Take it from here.
I guess I
happy to jump in here, Evan. So virtual mediation is very similar to what we're all doing right now. We're having a colloquy and a meeting, just not in person. We'll talk, I think this panel will talk in some detail about how that is actually accomplished. But the platforms, that I've worked with, and I know others on the panel have worked with, are primarily Zoom, WebEx, Microsoft Teams. Those are the ones that I've used, but I know others have worked with other platforms.
I would add that virtual mediations really they've become a new way of doing business, especially in law firm and other professional service organizations. The pandemic has had a lot of negative impacts on the way businesses do operate in the United States and around the world. But one byproduct of this, if there's a positive byproduct, is the fact that Zoom, WebEx, and other platforms have permitted industries like ourselves to continue servicing our clients, providing them with continued mediation services. Otherwise, if we didn't have this, then this line of business in the legal business would come to a screeching halt for the most part. So this has allowed us to transition into a new vehicle, as it were, that permits the business to continue without the in-person interaction that we have been so used to all these years. And I think once we complete this transition mentally and physically and otherwise, and get used to a new way of operating so that clients can be served, business of mediation and arbitrations and trials can continue. Once we get used to it, I think we're going to find it a very positive and useful mechanism for the conducting of our legal practices.
Well, let me ask the panelists, who chooses the platform? Which virtual platform to use? And are there differences? And does this create any issues, let's say, between the mediator and the parties?
Maybe I'll jump in on this one. I think either any party could dictate it. Sometimes mediators dictate the format that they would like. I've had that. I've also had maybe a defendant insist that they'd like to use a platform that is set up through their law firm. And I've also had a mediator do something I thought was very helpful, which is ask both parties what platform they would prefer. And for a joint session, there needs to be agreement on what the platform will be. Either party can set it up. But then for the separate sessions, for example, I do still like Zoom. I'm probably one of the individuals who prefers Zoom, whereas I have defendants oftentimes who like GoToMeetings or WebEx. And from that perspective, they can use what they're comfortable with and we can use what we are comfortable with. So that seems to work pretty well. And then, you know, if you think about it, the joint session's so much shorter than the entire day. So the parties can be in a platform that they're comfortable in. But I personally would use whatever someone insisted on. But if asked, I would like to use my own platform. And it's probably what I prepared my client on.
How does the mediator handle the situation where one of the parties insists that its platform be used and that it control the platform as the mediation progresses? Have you run into that issue before?
I have recently, where the defendant felt that there would be too much confidential and proprietary information discussed in the joint session and with me when I went into the breakout rooms and did not trust the security provisions, for example, with Zoom, which has improved its security from when it started. But they insisted on using WebEx, and I had not used WebEx until about a month ago. And through my law firm's IT department, became very familiar with it. And I still thought it was easier to manipulate as the host, going in and out of break rooms and using the chat versions on Zoom than WebEx. But I think it's just a matter of my becoming getting used to using WebEx. And at the end of the mediation, which did settle on WebEx, I felt comfortable, not as comfortable with Zoom because I've used Zoom many more times than WebEx. But in that case, everybody was okay in using WebEx just to get the mediation moving and started. At the end of the day, as I said, we were able to successfully resolve the case.
Yeah, and just from the union perspective, when parties use the FMCS, the Federal Mediation and Conciliation Service, the FMCS will provide the platform. They use something called Ring Central, which I think is the more commercial version of Zoom, and they do it all. The mediators control all of the who's in what room, who's in the common room, and I think the most salient feature of the FMCS's utilization of this this sort of platform is that it is free, and free is generally good when you're talking about negotiations, especially contract negotiations, which are typically held in some third-party venue. It's a hotel conference room. It's where there's all sorts of expense, and this virtually eliminates that expense, which can be quite daunting if you're a small union and you're in a big employer situation, or even vice versa with a small employer and a big union. the big union can, do it at once in terms of finances. The small employer maybe not. But if the FMCS is doing it for nothing, several of my partners have settled contracts in the last several months using the FMCS and having that platform available to them.
And Evan, I'd add one, last point to this, and you can hear it from the panelists. And we're 5 months now into this new world. I think it's very important as you're thinking of setting up a mediation or going to mediation virtually, that you understand whether you're representing the management side or some other side, that you understand whether your clients have any security concerns or limitations on technology that will drive one or more parties to a particular platform. And then that should be part of the vetting process, as in concert with the other side, as you think about and select mediators, because sometimes those security concerns or those limitations will really drive sort of who you need to work with and what platform you need to work with.
So does that dictate in part the mediator that the parties will select? How do you determine whether the mediator has experience with virtual mediation or the particular platform?
So from my perspective, again, we're only 5 months in, so this is still brand new for many people. But I do think that's part of, just as you would reach out for references on a mediator, and you would want, as part of that process, both with the mediator and with any references that you're given, you'd want to vet and ask these questions about the mediator's experience, whether it's generally doing virtual mediations or more specifically the use of particular platforms and areas where maybe the mediator excelled versus areas where maybe the mediator has some challenges. Understanding that, again, this is all relatively new, so few of us can actually claim that we're experts, particularly in multiple platforms.
What
I
are
would say from,
yes.
if I may just weigh in to echo Ariel's point, I mean, I feel like if you know one platform, oftentimes you can at least make your way through the other platforms. So I think I'm much more interested in knowing whether the mediator has done remote mediations, and I've started to ask that. And quite frankly, in the last few months, I've, I guess, been fortunate enough to do a couple of these, and certainly have some mediators that I find to be as proficient as anybody else, and it certainly makes things easier. It moves the mediation along. So I think I'd have more questions about the mediator's time in remote mediation virtually now in times of COVID, or before then, more so than the platform. I do think most mediators can navigate the platform. If they can navigate one, they can usually navigate the rest of them.
What are the basic differences that you see between mediation as we've known it for years and virtual mediation?
Well, one big difference is simply the time that is saved and the expense that is saved in traveling for out-of-town clients, out-of-town in-house counsel. There's insurance involved. They're usually out-of-town individuals. And just the sheer economy that virtual mediations provide the parties, so that they become more efficient in their time and the use of the resources that could be used maybe to help settle a case. But I think it's a matter, as I said before, of getting used to the transition and becoming accustomed to conducting mediations in this fashion. One thing I have found is that how the mediator manages this process is very important to gain the confidence of individuals, the plaintiffs, the unions, the defendants, and if they think that things are moving fairly smoothly and there are not too many technical glitches, they will have more confidence in the process and will be more willing to, I think, be upfront with the mediator because of his or her command of how they're managing this process, which becomes very important. And a part of that has to do, I believe, with the preparation that the counsel for the parties takes well before the actual mediation date, either the counsel talking with his or her client, explaining what the process is all about, maybe even doing a dry run with the mediator so that the client has more confidence and feels more comfortable about the process, and that this distance that is between everyone is not as bad, and we can feel, we'll never feel as intimate in a mediation as we would in person, but it certainly provides an avenue that is properly taught to the clients in particular, that it can be very successful.
Yeah, I just echo the main point that Marty just made is, the time saving of it. Certainly there's a reduction in travel. In the union world, there's something called an Article 20, and these are jurisdictional disputes between two unions. Typically, those are mediated in Washington, D.C., and if you don't have to travel to Washington, D.C. to do a mediation, your life improves immeasurably, unless, of course, you live in Washington, D.C. Those of us who are, practitioners in the New York metropolitan area, just getting in and out of Manhattan is it's a struggle, and it's been the struggle of some people's lives. Those of us who take the Long Island Railroad, affectionately known as the Silver Snail, you go from one place to another. It's an hour and 15 minutes, and then you got to get on a subway. If one thing that I have noticed about these in terms of time saving is that people tend to be on time when they start. Within a minute or two, 3 minutes, five minutes is, oh wow, somebody's really late, they're 5 minutes out. If I could get back half of the time I have waited around for other lawyers to show up to meetings, I would be 10 years younger, I'm certain of it. And that's a significant advantage to this sort of a platform over the more traditional meeting, and it is a significant difference as well.
Let's talk a little bit about what Marty just referenced. That is, and Ariel also, the need for pre-mediation session activity. In the normal mediation, I suppose you get together with the attorneys for the parties in advance and you talk about certain things. How does that differ when you're having a virtual mediation? You still get together with the attorneys. Do you talk about different things?
What I typically do is, before these virtual platforms, I would have 30, 45-minute individual calls with the lawyers prior to the actual mediation to go over what they have submitted in their written memoranda to me, and discuss the main points, good and bad, what's unique about the case. And I've continued that same process with the virtual mediations. And a couple of occasions, I've done a practice session with the lawyers using Zoom to conduct those pre-mediation conference calls, so that they can get used to seeing me, my seeing them, talk about any nuances about the particular platform, making sure that maybe even have a client of the lawyer there so that they can get accustomed to and hopefully develop some degree of confidence in me as their mediator. But that's been the typical process, so that's really not changed for me before we began with Zoom and WebEx.
And I've done, Evan, I've with virtual mediations, I've actually tried to insist may be too strong of a word, but I've really tried to encourage my client to have the pre-mediation, the typical pre-mediation telephone call with the mediator, to do that, on whatever platform we're going to use for the mediation, in part to do a test run to make sure that the client understands the technology, but also it's a great way to get to know the mediator. It's a great way to almost do a little bit of a test run to see how facile the mediator is with the technology. And it gives me a level of comfort that, my client won't be spooked by the technology and won't feel that they're somehow getting less because it's being done virtually, that as opposed to in person. And I actually think those kind of sessions, as Marty described, are a huge aid in sort of getting ready for virtual mediation.
And if I may say also on that same topic,
Yes.
I think people feel very uncomfortable with platforms they're not comfortable working in. So I think one thing that you can do, one thing that has been helpful for my clients is I typically prep them for a while on Zoom. I'll share my screen, do some other, whatever platform it's going to be, I'll share my screen. But I think for my particular clients, they feel much more comfortable. And when the mediator will get on the phone and do the joint, or get on the platform and do the joint session that way, that's helpful. I've also had, I do a fair amount of sexual harassment cases and sexual assault cases. And in those cases, the mediator most recently has been willing to hop on a remote session for 15, 20 minutes just to talk to the plaintiff, nothing about the case, just to give them some comfort as far as interacting with the mediator and understanding what it's going to look like the following day. I thought that added a huge level of comfort because, as Dennis said, most people are on at 10 a.m. and you get started right away. There's no informalities. There's no, the discussions tend to be a little bit less since everybody's just waiting. I found that that's helpful. One thing that I have thought was more helpful recently is when I asked the mediator if I will have share ability on whatever the platform is. During the mediation, there's often a time that I'd like to show the mediator a document, but some platforms, the way they're set up, they don't give access to individuals like me to share my screen or to show a document that I thought might be helpful if it's something that comes up in mediation. So I typically ask now at the joint sessions that there be a way that I can be given share of any kind. It might be that something comes up during the mediation that my client would like to share or I'd like to share with the mediator. And while I can email it, it's a whole lot easier if I can just pull it up and highlight it and do what I need to. So I think that's sometimes helpful. But as far as prep, I just think it's, at least for me it was, and for most of the people that I represent, it seems like just getting comfortable in the platform has gone a very long way in feeling comfortable in the mediation itself.
It seems to me that there are two fundamental issues at the beginning. And the first one has to do with moving people into rooms. When you begin the mediation, how do you know that the right people are together in the right rooms and you don't have somebody from the other side in your room or your room with your clients before the joint session of mediation begins? And the second has to do with the fundamental problem I see in typical mediations. There are exchanges of documents, exchanges of papers. How the heck do you handle that in a virtual mediation?
Well, what I typically do is when I have the individual pre-mediation conference with the lawyers, and I do this separately for the lawyers. I don't have everybody together. I will ask them to give me the list of names of persons who will be participating in the mediation, whether in person or in some other fashion. And so I'll have a list of persons who will be in the plaintiff's room, a list of persons who will be in the defendant's room. And when they come up on the waiting room, for example, in Zoom, I will see their names and I will assign them manually myself to a particular room when it's time to move them to a breakout room. So I know ahead of time. And if I see someone's name on the waiting room whom I do not recognize, I will go to the plaintiff's lawyer, the defense lawyer, and ask them whether or not they know that person. And if not, I won't let them in. But so I'll know ahead of time, and I'll put them in their respective break rooms until we're ready to start the joint session, and then I'll bring everybody out of their respective break rooms into the joint session. With documents, I will typically, again, ask them to give me the documents ahead of time. If they're willing to share them with opposing counsel prior to the actual mediation date, I'll ask them to do that. Otherwise, we can email them to one another during the mediation. It's very easy to do that. If you don't want to share them on Zoom, you can just set them up on your email screen and they'll come up. So I've not found that to be a problem. Most lawyers, especially when you've completed discovery, everybody knows who's got what documents, and they're willing to share them unless it's something really critical that the other side has not seen. They may want to hold back until the appropriate time during the mediation process.
Yeah, and just from a practitioner's perspective, Marty's talking about it from the mediator's perspective. From the practitioner's perspective, if I'm in the union room and I see a guy who should be on the other, who's a management guy, shouldn't be in there, there's an ability to click on a button, you get to the mediator and say, get this guy the hell out of here. And that's what's done. As far as the documents is concerned, Marty is right that it's, it forces the parties to think about them more. You don't just walk in with your file and go, oh, here's a piece of paper. Now you've got to sort of exchange these things up front. And I think that maybe make the whole thing more efficient, because the preparation is it's the coin of the realm here. So if we're all prepared, everything goes more quickly.
I just want to point out, I agree 100% with Dennis on that. I have seen too many lawyers in mediations who have not only failed to prepare themselves, but failed to prepare their clients. And so forcing them to exchange documents ahead of time at least gets them into the file, and they're not trying to remember. I mean, they should already have done that when they submit their written submissions to me. But I'm just amazed and shocked at how unprepared too many lawyers are, and the clients are looking at what appears to be a dysfunctional process when the lawyer is searching through the files trying to find a simple document that should be so obvious. So that preparation ahead of time, forcing them to exchange documents before the mediation date, helps with the preparation that the lawyer should be doing in the first place.
Remarking.
2 points. 2 points, Evan, if I could add. In terms of sort of what Dennis described as somebody ending up in the wrong room, what I always do at the beginning of a virtual mediation is we actually test that out. So the mediators will put people into rooms. We will go through a round of testing before the mediation actually starts. I certainly recommend that, just to make sure that it's been done correctly in the beginning of the mediation, but it then provides some confidence to the parties that the mediator has, a handle on the security. And of course, I agree with Dennis. If somebody happens to somehow get in the room, you can put an end to that pretty quickly. But I will say I've done a handful of mediations since March, and that has not been an issue. But we've made that a part of the upfront testing before the mediation kicks off. And then in terms of documents, well, the one thing I've found doing virtual mediations now is everybody's prepared to do things electronically. So even if something comes up that is the mediator asks a question or wants to see something that hasn't been part of the submission, we have it now available electronically or on our computers anyway. It's been very easy and seamless to share that document either through a document sharing feature on the platform or to email it to the mediator. And so I haven't seen really any slowdown or inefficiency. I agree with Marty that preparation has always been important for a successful mediation, but certainly preparation for this kind of a mediation is important because it's so new to everyone.
Yeah, one last thing on that, and Ariel is right. Most of this stuff is on our computers anyway. We can just hit send. But if you really get into a bind, there's an app called Scannable. You put it on your phone, you take a picture of it, you send it. It's done in 15 seconds. It's for short documents, it's especially helpful. And I had that situation probably a month or so ago where for some reason I couldn't locate something on the computer. Well, hell, I'll just do it this way, and click send, and you're done.
So I think what I'm hearing you saying is that in a virtual mediation, there is a need for both email and telephone, in addition to participating in the virtual mediation on screen. for purposes of,
Yeah, I certainly think so. And what I've seen, and I'm sure Marty can talk to it on his practice, but what I've seen other mediators do is they collect all of that information ahead of time. And certainly the cell phone and texting is a way for the mediator to do what he or she used to do when you're in a conference room. They want to have a private caucus with attorney only, rather than having to come and pull you out in front of the client to have that caucus. You get a cell phone call, you get a text saying, can I speak to you? And I've actually found that, in terms of sort of what works better in the virtual mediation, that ability to have a more discreet reach out by the mediator, and to be able to take that call without having to walk out on my client. I just found that to be, frankly, a little bit more elegant in terms of how to deal with those situations, and they happen frequently in mediations.
I agree. I've used those two devices, and it makes it much smoother, and it looks like you're managing the process better. And typically, you use either text or a cell phone call to the room to let the lawyer know, look, I'm going to be coming into your room in 2 to 3 minutes. Be ready. And then when I come in, they're not shocked or surprised. But you can also do that to let the lawyer know that you need to step out, or he or she needs to step out and have a private conversation with me before I go into the break room.
one of the things I'm hearing is that if you have a large firm platform behind you, whether as the mediator or as the attorney, you may have at your disposal certain devices and certain pieces of equipment that a solo practitioner or a small firm practitioner might not have. Do you see any downside to virtual mediation for that kind of practitioner representing, let's say, a small group of employees or a single employee in a case? Carla, you seem to have at your disposal big firm technology and assistance, but what of the attorney who is in practice by herself, who perhaps has maybe 2 or 3 people in the office? Is that person going to be disadvantaged by virtual mediation?
If I may jump in here, I mean, I'm a very small firm. And so I probably am on that side of almost a solo. I use Zoom with my family. I use Zoom. My son uses Zoom with his little friends to connect. So I think it is really something that can level the playing field. I mean, I really do. I think I've used almost every platform out there. I don't know that I've used Ring, Dennis, recently, but I find that they're all so similar. Once you figure out the functions of one, you can pretty much figure out the functions of the other. So I don't think that technology really disadvantages even those of us that represent the little guy and probably are the little guy as far as practice, or the little girl as far as practice goes. So I think that technology doesn't disadvantage any party. In fact, in some ways, I think it really evens the playing field.
Yeah, and the technology doesn't cost very much either. You can get a license for, this is GoToWebinar, you can get one for GoToMeeting. They're under $20 a month. You save that in the train ticket.
One thing I will mention is that if the lawyer is unfamiliar with the technology, because there are going to be technology issues that will arise in any of these platforms, that maybe investing in having a facilitator or some third party help you at least get started, so that you don't have those technical glitches that will invariably happen. I mean, I've experienced them, and I'm with Cozen O'Connor, and thank goodness I have someone helping me just in case, so I don't look too stupid as I'm fumbling around trying to get people's pictures back up on the screen. But once you get used to them, it's not a big problem. But initially, maybe having a third-party facilitator work with you to set up everything, and then after you get everyone in the respective rooms and you can move around and maneuver the breakout rooms, it becomes relatively simple.
Yeah,
And
I think.
go ahead, Ariel.
Go ahead. So I was just going to say, I think I agree with with Carla. I actually think that technology is a huge equalizer, and then add into the fact that, for the most part, we're all the participants are sitting in their homes in some fashion. And at least psychologically, I find that to be an equalizer as well. You're not in one person's office versus another person's office. You don't have that dynamic. You can see at certain parts in the mediation that people are in their home environment. And I think to the extent that there's this feeling that, someone has a physical advantage of some kind by location, that all sort of melts away with this technology.
And if I
Dennis,
may
you were
just say one more thing on that. Oh, sorry, Dennis.
No, you go right ahead.
I was just going to say the nice thing about virtual platforms is they have virtual training. So if you're going to use, part of the reason that I prefer Zoom is I've done the virtual training for an hour where they walk you through every feature that they have. So, for a small practitioner, being at home is probably a little bit easier because I don't have a third person that's doing anything else for me. I'm doing it myself. And if something freezes at 11 o'clock at night, I watch the video because I know I'm my own troubleshooter. So I think that is, extraordinarily helpful.
And what I was going to say was that, our, the five of us, our personal experience with each other just over the last week or so, we help each other out with, no, you got to get down to the bottom and push that button. And then, and that sort of relationship is, that's what's going to happen when you're on a virtual mediation or an arbitration or a contract negotiation. People are going to help each other out to advance the technology, which is, granted, it is this far away from where we really want it to be. It's that far away, but it's not really that far from being where we want it to be. As the demand increases and has, really gone through the roof, a lot of these companies have really stepped up their game, Zoom being one of them. At the beginning of all of this, Zoom had, security issues. And my understanding is that those security issues have evaporated. When this whole thing started, we adopted GoToMeeting because of those security concerns. But then, GoToMeeting has its own bars to climb over, and that's how this is all going to get better for all of us over a period of time, and probably not that long a period of time either.
I've run into a situation in virtual mediations where I have an attorney for one of the parties actively involved in the Zoom conference, the Zoom mediation, and that attorney has clients. Let's say a plaintiff's attorney is representing a half a dozen individual employees. That attorney has his clients or her clients on telephones, not on virtual, not on the Zoom, but only communicating with him. Now, as the mediator, how do you handle the situation where that, excuse me, that arises, and you have in the Zoom conference the attorneys for both sides, perhaps the employer or the company's key official there, but maybe another official for the company participating remotely, but only into the attorney's office, or the plaintiff's only communicating to the attorney. As a mediator, do you allow that? How do you deal with this? Do you deal with it in advance of the mediation? Do you deal with it when it arises during the mediation? What do you do?
Well, I have had that happen in instances where there's insurance and the insurance person wants to only become involved by way of telephone and when necessary. So they're not there, unfortunately, hearing all the dynamics of what is going on and the interactions between the parties. And so what I've done in the past is to get that straight before the actual mediation so that I'll know who is going to be where and doing what. And if it's a party, I mean, that becomes a problem because the party is not really engaged in the process by failing to hear from me, talk to me, and if they're only communicating with a lawyer by phone, I mean, it just really hampers the entire process, whether you're doing it in person or whether you're doing it by way of a virtual platform. So I really try to discourage that. And if the person can only be there by way of telephone, have them on the phone when I'm talking with them so they can hear me and I can talk to them and have them understand what is going on. But to have a party only communicate in a mediation by talking to his or her own lawyer is, I think, problematic. I mean, I think it hampers the ability to get the process moving.
Well, just, from a practitioner's perspective, if I didn't think the other side was taking the process very seriously, and they had,
Yeah.
they demonstrated that by, essentially shielding any decision maker from, participating actively, I don't know, maybe I would just ditch it. I've not had that experience, but, we've certainly had that. We've all had that experience in the non-virtual setting, and you come to that conclusion pretty quickly and you leave. No reason to stick around for that.
Sometimes the party or the individual or even the attorney is participating in the virtual mediation by sound only, by telephone. For example, is in the car driving while the mediation is going on and can speak but can't visually participate. Or perhaps somebody had difficulty getting into the virtual mediation through the video. There may be some of our participants in today's session who are participating by phone and not by video. How do you handle that situation in the mediation? Do you allow it? Do you prohibit it? Do you dictate in advance what should and should not be done?
I think my cases are probably a bit smaller than Dennis's or what you do with Martin or Ariel, but I just can't see a way that you can't look at someone's face and hear them. And I think for the clients, that would be a gross disservice. I mean, I don't know the circumstances of what came up, but I think your clients want to look at your face too as you're giving them advice. And, the nice thing about virtual mediations is, like you said, Marty, the carriers are more available. People are more available to jump into these sessions, and it doesn't require them to travel for a day and to stay from 8 to 10. You use your phone and you tell them when they need to be in the session and not in the session. So there's very little excuse for them not to be there. But I do think if you're doing it virtually, there is credibility that most people, business people, our clients use in order to make decisions. And not knowing the circumstances, I wouldn't want to say the lawyer isn't acting appropriately. I'm not suggesting that, but I just think it would be a disservice for the client who's hopefully going to go through this once or twice, an individual client who's going to go through this once or twice in their lives, not to be able to look people in the eye and get their honest advice. I think doing it on the phone would be very hard. I think it would detract from the ability to push a mediation towards closure, something the mediators do so fantastically. So I think being on the phone would be problematic, and I just don't see the reason nowadays. I mean, we're not driving like we used to be most of the time.
So you would just dictate that, you would dictate that as a requirement in advance of the mediation, the virtual mediation. That all
Or
of
do
the
it a different
parties.
So I guess, Evan, I have maybe a slightly different view on that, because there certainly in face-to-face mediations, I've had situations where important, but maybe not the key representatives from the employer side need to participate at some level. They don't need to be there all day. Maybe we get to a point where we need to reach a decision maker on money terms. And so very frequently, those people are available by phone. And so I can't say 100% of the time it's been without glitches. But certainly in face-to-face mediations, we've had lots of situations where people aren't present physically, but they've been available. I think that can still work, and it can still happen in a virtual mediation. I might go a little bit further and say, look, if somebody can be available by cell phone, it's equally easy to be available for some smaller period on a platform like this. And the beauty of these platforms is that the mediator, you don't all have to be present at the same time in the beginning to be a part of this. People can be added in, provided that you're giving the right notice and disclosure. So for on the management side, where there are frequently other people who may be part of the ultimate decision process who don't need to be on the Zoom mediation for the entire 10, 12, 13 hours, the ability to bring them into the room virtually is, I think, a really nice feature. And you get to have that. You get to have some FaceTime with the mediator and some FaceTime with the participants.
If I could just jump in for a second, and Ariel triggered a thought. Just a thing that I've discovered as well is just the basic scheduling of these things is easier, because you don't have to worry about who's in town, who's out of town, who's got a 3 o'clock meeting, who's got just the basic when can you meet is fundamentally easier with this sort of a platform than if you've all got to meet at some lawyer's office with 3 conference rooms and all the accoutrements that go with that. I think it's just easier to do it on this platform because and Marty mentioned this at the beginning, you cut out a lot of wasted time and motion.
One thing that I think, Evan, that's very important is, as I said earlier, to find out who's going to be all the persons attending for the plaintiff, the defendant, for the union, for management, whatever the case may be. Because what you don't want to have happen is something Dennis described, and that is you get there and you realize a key person whom his client wants to be there to hear what's going on is not going to show up. And so what I will do is say, tell me everyone who's going to be on your side present, on the other side, and then if there's someone who is going to be absent, who's a noticeable decision maker or who was involved in the facts that led up to the claim, I want to let the other side know that. So if that becomes a problem, we will just have to reschedule. But I don't want people showing up and a plaintiff who wants to tell her side of the story or his side of the story in a sexual harassment case, Carla, for example, is not there to hear that client vent, because sometimes that's a part of the process of settling the case. Then I don't want people wasting their time coming to my office, whether they're all in town or not, to find out that the key person is not there.
So Evan, related to that, before we move on, I did see that there was a question from one of the attendees. I think that's related to what we're talking about, and the question is sort of what our thoughts are about one side being physically present with the mediator for the mediation and the other side being present virtually. And as I saw the question and thought about it, I think ultimately, parity in sort of situations, particularly in a mediation, is really important. And I certainly, I think, would not be comfortable sort of having one side there physically present with the mediator, if the mediator would even permit it under the current circumstances, with the other side being virtual. I think that does present maybe some potential disadvantages.
I've not had that happen yet, but if we're going to be in person or we're going to be by virtual mediation, but I don't want someone present physically in my office and the other person participating virtually. I just think that just leads to too many problems and unintended consequences in the process of doing it that way.
But that flexibility can be employed, I think, within the party. So if I'm doing contract negotiations and 3 people are with me in my conference room and 3 other people are participating virtually, that's fine.
I agree with that scenario.
Let's talk about the breakout rooms for a moment. In the typical mediation, as the mediator, I might spend 30 minutes in a breakout room with one side and then go back to the other side and spend 30 minutes there, but it also might take longer. How do you handle the back and forth as the mediator, back and forth? And as a party, do you feel lost and left out if the mediator has not communicated with you for an hour, let's say?
Well, I'll tell you, after the joint session, which I typically want to have a joint session, even if it means I'm the only person talking, so that I can set the scope of what we're doing, the parameters, and make people feel comfortable. And lawyers, I'm finding more lawyers are not wanting to give opening statements for a lot of various reasons, but I try to push them to give an opening statement, at least an abbreviated opening statement. But I'm seeing more lawyers not wanting to do that. But what I will tell them at the end of the joint session is, look, I'm going to spend about 45 minutes with the plaintiff. And if I stay longer, I will send you a text and let you know I'm going to be delayed a little bit so that they're not getting antsy and not thinking I'm spending an inordinate amount of time. Because when I go to the other side, I may spend half that amount of time or 30 minutes. And they'll wonder, well, why did you spend so much time with the other side and only 30 minutes with us? And so I try to explain that to them in the joint session about the dynamics of moving from one room to the next and what I'm doing. And try to beat up on both sides equally if I can, if I need to, so that people won't think I'm beating up on them and not the other side. So just getting all those ground rules put on the table at the very beginning, and then notifying parties in the other breakout room that you're going to be delayed or that you are delayed for whatever reason, I think allays any fears in the other side's mind about, am I cozying up to the other side? Am I trying to get more information from them than is necessary? You've already talked to the lawyers by way of Zoom prior to the mediation. What are you doing? And I found that to be a mechanism by which parties are okay with that, so long as I let them know why am I spending now an hour and a half with the plaintiff instead of the 45 minutes I told them I would spend in the joint session.
On the Zoom platform, that's fairly easily accomplished if you're running late.
Right.
And it really is just, click a couple of buttons, say, listen, I'm still talking, I'll be back in a couple of minutes, and then, you back into the other room.
Have you run into any problems with the use of translators in your mediations, particularly in connection with virtual mediations? And how do you handle it if go ahead, Ariel.
Ariel, were you going to say something?
No, I had said I haven't come across the issue of translators, so it's just not been something I've had to deal with.
I had a mediation recently where, as the mediator, the translator was trying to simultaneously translate. Now, in face-to-face mediations, that's easy because the mediator can be whispering in the ear of the party or of the employee. But in a virtual mediation, trying to conduct it with a simultaneous translation just absolutely obliterates the sound from the mediator or the sound from the parties or the witness. Have you run into that problem at all, and how do you handle it?
I have not, as a mediator.
You can try to have the mediator wait. You can speak a little slower or let the mediator have some time to translate, but simultaneous becomes a problem. Let's get back to the exchange of documents. I think you said at the beginning of this webinar that you try to take care of all the documents, exchanging documents in advance of the virtual mediation session. But how do you handle things if you haven't? If there's a document that hasn't been pre-marked, if a party has a document that they wish to refer to or to distribute during the course of the virtual mediation, what do you do about that? How do you, as attorneys or as the mediator, handle that? Is there a way to exchange documents that have not been pre-exchanged and pre-marked before the virtual mediation?
Well, I think as Ariel said before, I'm sorry, go ahead, Carla. You're in.
Go ahead, Dennis.
I think as Ariel said before, much of this stuff is on your, is on your desk, it's on your computer anyway. You can email it pretty quickly. I mentioned the scannable app, but there's also, and I'm not nearly as comfortable with this as I want to be. There's in many of these platforms, you can share, you can become the presenter if you're not the presenter, and when you're the presenter, you can share your screen. And again, I'm not nearly as comfortable with this as I want to be, but many people are. And Carla, if your experience is that you're more facile with this, I'll turn it over to you. But I think that's really how it's done.
Yeah, I love the share screen option. And I mentioned earlier, it's typically something that you would want to ask the mediator if they're controlling the platform, if they're willing to give you access during the mediation before you get to that point. I think sometimes they just don't exactly, sometimes they're just not sure how to give you access. So if you ask it before you get there, you'll get it. But it's wonderful. And I think, there's always times that you got an email, somebody sent an email that was key, the morning before the mediation, and you can email it, but there's nothing like blowing it up on the screen and having the ability to read it along with the mediator to really show them what it is, whether it's an affidavit that you got that morning, whatever it was. But I do think there's some, at least for me, when I read emails, sometimes I have to read them 6 times to find the one line that is the real issue there. So it's nice to be able to read it for someone so that they can see the item. But screen share, I think it's fantastic. On all of these platforms, there's usually a way to do that, and makes a huge difference as far as a late received document as far as doing that. But I'll usually email a copy too, and if it needs to go to someone else, I'll email it. I just like the ability to walk the person through it and our mediator through it and make it easy for them.
Yep, and I would echo that, and I found that particularly where when we're I handle a lot of wage and hour cases, and when we start talking about some of the math and the numbers and calculations, the ability to pull up on a shared screen the spreadsheet, and to walk the mediator through the spreadsheet and calculations rather than sending it by email. I agree with Carla. It's much more, I think, much more powerful, much more instructive. And then if there's some part of that that needs to go to the other side, like Carla, I would email that as opposed to, agreeing to, a screenshot or a photograph of some kind of my screen sharing.
What is the whiteboard, and how do you use that in virtual mediation? Have you used the whiteboard technology?
I personally have not yet.
Yeah, it's a technology that allows the mediator or the parties to actually draw or write on a blank page whatever it is, either the calculations or some other aspect of evidence that might be relevant to the mediation, or even when the mediation has successfully concluded, the salient points of a term sheet. That is available, I know, on Zoom. I'm not certain whether that is available on all the platforms. So I gather you have not used that in your processing.
No, not yet.
It's one step removed from downloading exhibits and other documents in advance and having those available during the virtual mediation. What do you do about term sheets and tentative agreements that have been reached? How do you memorialize them in a virtual mediation?
What I typically do, and I think it's because I'm an optimist that believes every case can be settled, I will, before the mediation date, send, usually the day or two before, my form mediator settlement agreement. And it's form language that you would see in any of these kinds of documents. And I have the names of everybody there, the parties, the counsel, who's approving. I don't put obviously any terms there because I don't want anyone to prematurely think I'm leaning one way or the other in the terms or the dollars in particular. And send that to the party the lawyers, so that they can share it with their clients to read the form language. And then I'll either ask if we reach a settlement, either the defense lawyer, the plaintiff's lawyer, fill in the blanks. I want them to do it so that they're describing it, not what I think they're saying should be in there, especially things beyond the dollars. And they'll send it to the other side and to me simultaneously. We'll look at it. We can make changes. It's in Word, so people can make changes to it. And then to sign, you can get them to sign off on it, or if someone wants to sign it with their own signature, they can do that and just send it around. But I typically will not let the parties shut things down until that document is signed by everyone that day, because I've seen weird things happen when it's not completely sealed, signed, and delivered that day. And it's not been a problem.
Yeah, I've had mediators. Now I can't think how far back because it feels like it's the norm, but I've had mediators always tell me to come into the mediation prepared with a draft term sheet, and the mediator typically will ask me at some point during the process, A, do I have a term sheet prepared, and B, am I prepared to share it with the mediator, if not the other side? So my practice has been now for many years that I come into the mediation with a pretty comprehensive term sheet already drafted, obviously leaving out the terms that I don't know, such as the dollar amounts. And I will give a shout out to my California colleagues who have taught me they actually go into their mediations with settlement agreements, and they don't leave that mediation if they reach agreement without that settlement agreement signed. And I've adopted that practice. I think particularly for discrimination cases, I think you can cut out the term sheet step and go right to settlement agreement. And so it's different for wage and hour cases where I'd like to have a very comprehensive term sheet. But as Marty said, and I know Carla does this as well, I go into the mediation with something ready to go, because typically it's late at night when we reach agreement, everyone's tired. And to start that process from scratch is, I think, a recipe for disaster.
I completely agree, Ariel. And for discrimination cases and the ones like I handle, I just don't think there's any reason to have a term sheet. It's just a holdup. Most of the time it works for parties. And frankly, I don't care whether the company wants to use its own version of a settlement agreement. I will prepare a version if you want it. But I usually ask, if you get it to me about a week before, I can just redline it and come back into you. Because, if we do reach an agreement, then all of a sudden you're not sure if you can pay by X day because you have to check with payroll. And we could have done that when we were twiddling our thumbs in the separate caucus sessions. So some mediators that I've worked with will require, in cases like mine, the parties to exchange their settlement terms at the settlement agreements at the same time as their mediation statements. Or if the defendant insists on using theirs, the defendant will get theirs to me with their mediation statement. That way I can redline it. And I always ask from 10:30 in the morning, this is our proposal, but can I get there? Do they have any changes to my red lines? Do they have any changes to the red lines? And what I typically get, both in these mediations and also in the virtual mediations, they'll say, we'll talk about the agreement after we get to the number. And sometimes we just have to agree not to talk about the number anymore, just get the settlement agreement done. But I think from a plaintiff's perspective, it's a disservice to the plaintiff, because now they're waiting 3 months for something that they could have got 20 days from now or 10 days from now, simply because we were arguing over the agreement. Also, we sometimes need your help, Marty. We have some little issue, and if we had just brought it up while the mediator was still with us, the mediator probably would have solved it. The parties could have signed it at night, and then we're done and on our way. And I would say there's only one time that I've left a mediation without getting the agreement signed, and that case is in a motion to enforce in court. So that's what happens, I think. So I won't leave without getting the agreement.
Yeah, I've been seeing more of the plaintiff's lawyers in particular, and defense lawyers, bringing their form settlement agreement and release the long form to the mediation on the computer, and they're making the changes because they want to get it signed and delivered, then get the check within 10 days. And it's really sped up the process a lot doing it that way. But I've seen that the last year, the lawyers coming with the long form, release and settlement agreement, and sometimes they will exchange that form with the other side. If the lawyers know each other, they've dealt with each other, one another, they'll know there's nothing distasteful usually in the foreign language. So I think it's a good idea to do it if you take the time to do it.
I've also, just related to that, Evan, I once in my history agreed to a mediator leaving the mediation before the parties had actually signed the term sheet. And the mediator had to run a personal errand. And it's the one time where things really fell apart. So I, very politely will always make sure ahead of time that the mediator will be with us for, and I'm sure that's Marty's practice, but to make sure that the mediator's with us throughout so that we don't have these kind of hiccups.
Absolutely.
One of the problems that I've run across as a mediator is that a term sheet that the parties might sign at the mediation, and which includes a provision that says the parties agree that within the next 2 weeks, 3 weeks, 4 weeks, they will reduce their agreement to a long form agreement incorporating these and other standard terms and conditions. And somehow that second document never gets negotiated and agreed to and signed off on. So as a mediator, what I've done now is I've added a term to the term sheet that says if the long form agreement is not agreed to within X number of days, this term sheet shall be deemed to be a final and binding agreement.
Yeah.
And that would be applicable whether it's a virtual or an in-person mediation. Have you run into an issue in your mediations, either as as counsel for a party or as a mediator, involving security in terms of one of the parties wants to record on virtual mediations? If this were an in-person mediation, you would be aware of, you would see somebody who's recording the in-person mediation or parts of it. On a virtual mediation, how do you avoid that issue?
So I think whoever is sort of hosting the mediation, and which is probably 9 times out of 10 the mediator, that function, whether it's on Zoom or WebEx or some other platform, can be disabled. And there should be, as part of the mediation agreement, explicit agreement up front on the issue of recording or not. I will tell you that I would never agree to record the mediation. It's it's supposed to be a confidential process, and so that would be, I would look for that provision in the mediation agreement, and if I didn't see it, or if it wasn't tailored specifically to a virtual mediation, I'd want to make sure that that's in there so that we have agreement up front that the mediation would not be recorded in any fashion.
Short of an agreement in advance, in a face-to-face mediation, you will see and you can raise a fuss about and object to somebody recording all apart. But in a virtual mediation, if then, aside from using the record function, which is available on Zoom and the other platforms, are not using it, and the mediator controlling the use or non-use of that, in a virtual mediation, how do you prevent someone, whether it's an attorney or just one of the parties, from surreptitiously recording? Is that a downside of virtual mediation that we haven't found a way to overcome yet?
I'm not entirely sure that you're able to preclude surreptitious recordings, whether audio or even video, of in-person mediations. Certainly somebody with a cell phone could put it in his or her pocket and turn the audio, the voice memo function on, and they're recording. I don't think there's any, right now, if I wanted to, I could take my iPhone and, record all of you. You wouldn't know I was doing that, presumably. There might be a small camera behind me, and you wouldn't know that either. I'm not entirely sure you can prevent it. Willing to be educated to the contrary.
No, I think, Dennis, you're right. I think you're right that you may not physically be able to prevent someone from doing that, but you should know the law in your jurisdiction on when such a recording needs mutual consent or any kind of consent. And I would say build that into the mediation agreement. So in Massachusetts, for example, you need both sides to agree to have a valid recording. And so you could set those terms up front in the mediation agreement that either one party or neither party agrees. And so even if it is surreptitiously recorded, it won't be admissible for any purpose. And in fact, they may be subject to criminal penalties for doing it.
And in New York, where it's a one-party consent, you could also upfront, at the beginning of the mediation or any virtual meeting, say, I do not consent to anything being recorded, and that would have the same effect, even if it's not in a formally written document.
What do you do? What do you do if you have a multi-state mediation going on? How do we know which law of which state is going to govern what goes on in the mediation process?
So it's a really good question, Evan. And in preparing for this, we talked a little bit about this. There is actually some case law out there, particularly where parties are located in different states. So if the mediator's in Connecticut and one party's in New York and the other is in Massachusetts, what law is going to govern? The mediation statement may say something in it to that effect. I think maybe the easiest approach is if you've got an ongoing matter that's being litigated, which is what's being mediated, then I think that it's most likely the law of the jurisdiction where the case has been filed. But I think the important point for practitioners is we don't typically have all the parties sitting in different states for mediations. Typically, people come together in one central location, and so you don't have these kind of issues come up. So I certainly would encourage people to, if you're going to have a multi-state mediation, is look at the laws of the different states that might be implicated, and at least come to an agreement in the mediation statement on what law is going to apply as it pertains to the confidentiality of that mediation.
That's a good point. Very good point. In terms of, excuse me, in terms of the downsides of virtual mediation as opposed to in-person mediation, does it make a difference that in virtual mediation we're only seeing head and shoulders typically? Is that something that becomes relevant when you're looking at the parties, when the parties are evaluating witnesses, trying to decide whether this case should go to trial down the road or should settle up front? Are you going to miss the body language, things that you would see in person if you're only seeing head and shoulders of the particular individual? What do you think about
using head and shoulder shots? It gives you as good an indication about the person's credibility and their veracity for truth. You can't see someone hitting the lawyer hitting the client, or somebody scribbling and doing things that that they're nervous, or you get a sore spot, or people doing a number of other things that don't affect credibility as much as seeing the person from here on up. Because once you can see the shifting eyes and the nervousness on the face, if they're sweating or just moving around like this when you've hit a sore spot, that will give you, I think, as good of an indication or indications about their veracity, the truth, and their credibility. But you do lose some. I mean, you're going to lose some naturally because you're not there in person seeing the individual from head to toe. But I don't think it's that much lost by judging credibility by way of virtual platform.
So what I think we're hearing from the panel up to now is that probably the most important aspect of virtual mediation is in the pre-mediation session activity. The need to have in advance, excuse me, telephone conversations in advance of the virtual mediation session, agree on documents, pre-numbered documents, identify witnesses, talk about the ground rules, even to a greater degree than you would do in the normal face-to-face mediation. I think I'm hearing that from everyone.
Yes.
And are we hearing anything on the downside at all? You've all talked about the upsides, the advantages, but are there downsides? Are there disadvantages? Are there things we should be avoiding in virtual mediation? Aside, let's say, from the mediator who's totally unfamiliar with the platform or the process.
So
If I
actually,
may-
Carla, if you don't mind, before we answer that, let me just give out the CLE code, folks, and then we'll hold everyone in suspense for that answer. So just a reminder to folks that as part of the attachments to this program, there is a CLE form that you can use to fill out with the CLE code. And then that form, once you fill it out, should be emailed to CLE@seyfarth.com. Seyfarth is spelled S as in Sam, E-Y, F as in Frank, A-R-T-H. And the code is S as in Sam, S as in Sam again, 9898. So again, S as in Sam, S as in Seyfarth, 9898. All right, I apologize, Evan, for interrupting.
No, thank you, Ariel. That's, I think, probably more important than anything else we've said today. One of the disadvantages I find to mediation is that I miss out on all the donuts and the coffee that the mediators tend to bring to the session, or the law firm will set up for the mediator's enjoyment. I have not found any way around the for virtual mediation how to handle that, and I won't even ask if any of you have. But just to kind of sum up in some brief way, if each of you could just comment on your overall view of virtual mediation in today's environment. Carla, do you want to start?
Sure. I think virtual mediation is a great way to move the case forward. At the end of the day, I do think it's not good for our clients for their cases to be sitting in limbo for long periods of time. I mean, we lose evidence, we lose momentum. There's a cost every day that we're communicating with each other about when the case will ultimately move forward. So I think it's key. I regret waiting, putting mediations that we could have had in March in June, hoping that would be in person. If I could redo it, I would go ahead and set them for 3 weeks from now so we could move the case forward. I'll just say one note, and you had asked about risks as well. It is so important that the platform work, and there will be glitches, but you can do things like, I see, Dennis, you're wearing earphones. You can call in, if you freeze up, at least to keep the mediation moving forward. I'd mentioned a while ago that I had a mediator who gave a great opening statement, I think everything he said was wonderful, except I only caught every fourth word. And so I was trying to piece together what it was that he said. And when the mediation ended earlier, not because of us, the defendants, but when it ended earlier, I think he really couldn't pull them back together the same way he would have been able to if his platform just worked. So, you know, I think the platform working, it's for all of our credibility. We tell our clients, I tell my client it's going to work just as great. And if it doesn't, then, you know, that's a problem for me too. So I think it's an important thing to do. Cases shouldn't sit. They just shouldn't sit. It's not fair to the clients.
Good point. Very good.
Yeah. You know, I think the future is, you know, we're sort of living it. To borrow a phrase from an old song, we don't know where we're going, but we're on our way. And we're all in the middle of, well, in the initial stages of this brave new world we're about to embark upon. And I think the thing that is going to be the coin of the realm is flexibility. Flexibility is going to be the new currency. And that's for law firms and their, you know, their ability to maintain and attract legal talent. It's for mediators and their ability to get hired by litigants. If you're a mediator and you're not in on this already, you are 4 months behind and maybe 40 years behind. Almost immediately after things were shut down, I was getting calls from mediators and arbitrators about, you know, what do we do? What do we do? And, you know, these platforms became sort of the only way of doing business for a period of time, and now an indispensable way of doing business. And I think that's what we're going to find going out into the future, is that this is how we're going to conduct our business, both as law firms, litigators, negotiators, anywhere in business. This is how it's going to happen.
No, I
Thank you,
couldn't agree more with both of you. The legal profession has historically been slow to embrace technology, but I forget now who talked about, Marty, it may have been you in the beginning, just the sheer savings in expense and in time that virtual mediations provide over in-person mediation. On the management side, our clients have been having virtual meetings for years. It's what they expect of themselves, and they certainly expect from their vendors, including law firms. So I embrace it. I think it can be incredibly efficient. It can be very effective. But I think Carla really touched on it, like everything, whether it's remote, virtual depositions, virtual arbitrations. You need to practice. You need to get instruction. There are all sorts of vendors out there who are looking to have you go through training programs. The key to doing this well is to put in some time to learn how to do it. And then I think everybody mentioned this. Once you do it well, that engenders a high level of confidence in the process.
Good points. Good.
Yeah, and I would just say, as a mediator, we're now be giving an opportunity to develop quality mediation services by way of virtual mediation. It's something we've not ever done before, but it's like anything new. I mean, people like a meeting in person rather than being on the telephone, or they like going to a Broadway play rather than watching a movie, or watching a movie and Broadway play. I mean, there's so many things that you can compare this to, but I think what we need to do is look at mediations virtually, as well as arbitrations, and figure out how we can make this work and give a quality process to resolving a dispute between litigants. And once, I believe, people have that right mindset of moving forward, this is not going away. Once the pandemic is behind us, which we don't know when that will be, but once it is behind us, people will have been so used to this process. They're not going to want to go through riding trains or getting on airplanes or driving 4 hours to another city just to be a part of a 4 or 5 hour mediation, because the loss of the downtime is significant, what we've been experiencing. So I think it's here to stay, and everyone has to embrace that. And once they do, I think it will change the whole dynamics about how we're doing business in this country and around the world, because you can have Zoom in foreign countries. You can be doing this through so many mediums to help parties not flying to the UK for a deposition, when you can just do it like this and have multiple venues where people are using this process to conduct business. And it's going to save a lot of time and money, and it's just something we've got to get used to. And I think once people get used to it, they'll find, why did we go? We're not returning to the old way of doing business anymore. We've got better things to do than sitting in an airport waiting to catch a flight to a remote location just for the sake of being present in a deposition or a mediation.
I think I think you put it very well, Marty. And I think that once the mediators become more familiar with the process, once litigants, attorneys become more familiar with the process, we're going to find that, provided that we conduct pre-mediation session, exchange of information, pre-marking of exhibits and documents, exchanging of that before the actual mediation session, as long as we ensure the confidentiality of the process, that virtual mediation is the wave of the future. There's just no going back. We've all, I think, summarized it very succinctly, that there's no travel time. There's no travel expense. There's no overnight hotel. There's no airfare. There are little, if any, delays. People will participate at the appointed time, and they won't be delayed 30 minutes or an hour by traffic tie-ups or bad weather or whatever has occasioned these kind of problems in face-to-face mediation sessions in the past. Nationwide, worldwide mediation will be available. Mediators from all around the country will be available to sit in your cases as litigators, as representatives of the parties themselves, major corporations with executive offices across the country will be able to participate in a virtual mediation wherever it's set up and however it's set up. The kinks that we are experiencing in virtual mediation today will be overcome as each week progresses, each month progresses. And most of us already see that there are so many advantages to and so few disadvantages to virtual mediation that virtual mediation is here to stay. I don't see any questions from the audience. If there are any, we do have a few minutes to add. If there are any questions from the floor, please send them along to me.
Yeah, Evan, I think I can see some questions. I'm happy to read them. They're
Yes, I don't see any. Go
on the
ahead.
screen.
Go
So
ahead.
there's one question that says, are you finding the process more informal through use of virtual platforms, leading to quicker and more resolutions? So I don't know if somebody wants to take that. I have found, my experience has been that my virtual mediations have been as lengthy as in-person mediations. Other than what people are wearing, they're not less formal. And I really have found very little difference from a sort of formality perspective, and no difference in the sort of number of cases or percentage of cases that settle virtually versus in person.
I would agree with that also. That's been my experience, Ariel. If they're going to go 12 hours, they're going to go 12 hours either in person or by way of virtual platform. So I have yet to see the time for me and the time of the mediation having been
Any
There
other
is also
thoughts?
another,
Go
sorry,
ahead.
I was gonna say there's another question, and maybe I won't jump the gun. Maybe Carla might be able to respond to it. The question is, have you had any clients that have only cell phones that they can use, and do any of the platforms allow for just cell phone use only? And then there's a comment that many employees have limited technology, but all have cell phone access.
From my perspective, yes, all the platforms have cell phones. I don't want to do a virtual mediation with just cell phones. I think they don't get to see the mediator or hear their thoughts in the same way that they would if they were virtual. And I know this is probably not a great answer, but it's your one case, right? So I'm sure you can find somebody that has a computer that you can get to for that one day, even if it's a neighbor, kid, colleague, something. I expect you to be, for a virtual mediation, I expect you to show your face and not be on the phone. I think it's good for the client, not for me. I think it's good for the client.
Let me mention one thing on that, Carla, and that is I've been surprised twice this year where people have wanted to participate in a virtual mediation, but the laptop or desktop they're using does not have a camera. So they can see you, but you can't see them because they don't have a camera. So that's one thing they need to make sure, that whatever computer equipment they're using, that there is a camera for them to be seen.
They
And I would
also-
just say that goes back to us prepping too. When you prep your client, prepare them in person so they see the platform and know how to use it and can get set up. If the computer dies, they know how to dial in on their cell phone and still see you if that's possible.
And the technology will catch up to a lot of that too. Almost every laptop today has a camera on it, and even for desktops that don't, the peripherals are fairly easily acquired and they're very inexpensive in candor. You can put a camera on top of your monitor, and it's 30, 40, $50. They're not a lot of money anymore.
I see one question was asked, and I think it's probably directed to Carla. For settlement agreements and discrimination cases, how do you handle the Older Worker Benefit Protection Act 21-day requirement and 7-day revocation period requirement?
Well, it's only 21 days if they take the 21 days. If they opt to sign it that night at mediation, we're talking about payment in 8 days from the day that we're sitting in mediation. So I don't think it prohibits it. And to be honest, what I am finding in mediations nowadays is a lot of insurance companies are saying because of COVID, they're struggling to pay in less than 20 days. So it hasn't really been a challenge. I mean, usually I think 20 days is a long time. If I could get to 8, that'd be perfect. But anything in between that time works fine. I have not found the Older Workers Benefit Protection Act to be an impediment in real mediation, in real-time mediation and virtual mediation or anywhere else.
Thank you. Have the parties been willing to engage in practice sessions? Doesn't that run up additional expenses and costs on the parties and their attorneys?
You mean dry runs of the technology?
Yeah, I mean, Marty, you discussed to some extent having extensive pre-mediation session conferences, telephone conferences with the parties. Do you find that they are reluctant to participate in too extensive pre-mediation sessions?
It's not that extensive. I mean, what I normally do with in-person mediations, I'll have a 30, maybe 45-minute telephone call with the individual attorneys, and I encourage them in those calls to have their clients present so that they can get introduced to me and hear me. But since virtual mediations, I've been encouraging them to also have their clients, if we want to do that call, make it a virtual mediation call where the client is there also and can see me, and I can talk to that person, make them feel more comfortable and that kind of thing. But it's not very long. Sometimes those last 20 minutes or 30 minutes, and I found that plaintiffs enjoy it. And they want to talk, they want to hear, they feel more comfortable, and I'm ready to go. And so that any fear they may have had by being on camera and not knowing how they look and that kind of thing goes away, and people are ready to go on mediation day.
Yeah, and I think the prep session that Marty's talking about there, that gets eaten up by one ride on the silver snail. So you're not worried about the cost and expense there.
I think we've responded to all of the questions that I've seen on the question board. We've also exhausted our time allotment. It's a few minutes after 2 o'clock. Everyone has the CLE number and the instructions at this point. There are also 3 other handouts, substantive handouts, that people might find interesting. With that, I'd like to thank all of you, Marty, Dennis, Ariel, and Carla. I look forward to many more virtual sessions down the road. Thank you very much.
Thank you, Evan.
Thank you, Evan.
Thank you.
Be well.